Hello Facebook, Matt Dubin here, Washington State Personal Injury Attorney. It's 2 o'clock and this is our second installment of FAQ Fridays, where I answer your questions about car insurance, personal injury claims, or anything else related to personal injury law. And we've got some great questions this week, so let's get right to it. And the first set of questions we have, actually, the first one is from Adam. And Adam writes, my friends got in an accident 3 months ago and have already started a claim with the insurance companies. Can they still get a lawyer? When is a good time to decide when to get an attorney to represent their case? And, we had some technical difficulties. We're back. I hope you're all still there. I'm not sure what happened, but we're back live. So, again, Adam's friends were in an accident 3 months ago. They've started a claim with the insurance companies, and he wants to know, can they still get a lawyer? And when do you know, how do you know when is a good time to hire a lawyer to represent you in your case? Adam, it's a great question. It's not too late for your friends to call a lawyer. In fact, if their claim is, well, frankly, I encourage them to consult with a lawyer regardless. I encourage people who have been in an accident to consult with an experienced personal injury lawyer as early as possible after the collision. And the reason is because the insurance companies are looking for ways to reduce what they're going to pay out on the claim. And they start doing that from day one. It's not at all uncommon for claims adjusters to contact injured people in their hospital bed, sometimes the day of or the day after surgery when they're still heavily medicated, to try and take statements, and they're looking for anything that they can use to ultimately reduce the amount that they need to pay out. Even in smaller cases, people don't know what they're legally required to do and what they're not required to do, and the insurance company isn't going to tell you. They'll give you paperwork and tell you to fill it out and sign it. They'll call you and ask to take a recorded statement as if you're required to do that when you're really not. Having a lawyer on board as early as possible in the process can really help. Now, if you don't do that, if you do start the case yourself and open a claim and speak to the insurance company and try and get it done, it's still not too late. The only downside is you may have already done something that gives the insurance company ammunition that they certainly won't hesitate to use against you later. But you can hire an attorney at any step along the way, and we can step in and make sure that things are being done right. If you've given the insurance company permission to dig through your medical records or other things, we can put a stop to that and make sure that we're giving them just what we're required to give them and do our best to undo any harm that might have been done before we were hired. So thanks so much for your question. A related question from Jeff was, what are the trade-offs of negotiating directly with the insurance company versus hiring a personal injury attorney? And there are certain situations, particularly very, very small cases. Maybe there's no damage to your car, you feel better within a couple weeks, where it's probably not worth getting a lawyer involved and paying a 1/3 attorney fee. Because in a case like that, your recovery is going to be small anyway. But in almost every other case, hiring a lawyer makes it easier for you and more likely that you'll walk away with more money at the end of the case. And you just get the peace of mind knowing that somebody who knows exactly what your rights and obligations are is looking out for your best interest. The insurance companies don't have your best interest at heart. Your attorney does. And that's why it's so much better to have an attorney from the beginning. So thanks for your question, Jeff. Danny asked, how do personal injury lawyers get paid? And I already mentioned the 1/3 thing. So most personal injury lawyers get paid on what we call a contingency fee. And what that means is the attorney only gets paid if they can get a recovery for you, and then a percentage of that recovery. A standard fee is 1/3 of a settlement. So in that example, if an attorney recovers $90,000 for you, we just had another technical difficulty. It looked like it froze for a second. I think we're back. I was talking about contingent fees. And so in that example, if the recovery is $90,000, the attorney fee would be $30,000. Now you're still responsible for the expenses of your case. And expenses could include things like the cost to obtain your medical records or using legal messengers or even something as simple as stamps and photocopies. But in general, if an attorney doesn't get a recovery for you, they don't get paid. And there's no upfront cost to you. And that certainly is the case with our office. Finally, and something that's very timely, sorry about that shake. Something that's very timely has been in the news here in Washington is our new DUI-E statute, which is driving under the influence of electronics. And what this does is it makes using your cell phone while you're driving a primary offense, which means the police can pull you over for it, and doing other activities that distract you while you're driving, like eating or drinking a cup of coffee, can be considered secondary offenses. So you can get a ticket for that as long as you're pulled over for some other reason and the police believe that it was a factor in distracting you from driving. So Billy's question is, how will the new DUI-E law affect suits against distracted drivers? And that's a really good question. So the new law does not address civil claims, which is what negligence is. It's a civil claim for money. However, the law in Washington says that violation of a statute, such as this new DUI-E law, can be considered by a jury as evidence of negligence. So everyone using the road has a duty to exercise reasonable care. If you don't exercise reasonable care, you are negligent. And if that negligence causes an injury to somebody else, you or your insurance company is going to be responsible to pay. So while this new DUI-E law doesn't create any new civil causes of action, it does create a statute that can be considered by a jury at trial in determining whether the driver was negligent. Now, I'll tell you from personal experience, if I have evidence that the defendant driver was using their cell phone when they hit my client, I'm telling the jury about that anyway, and they don't need a statute to know that that's negligent, that that fails to meet a reasonable standard of care. And so we already use it, and juries already understand that it's not okay to be driving and texting at the same time. If you're doing that and you hit somebody, you're going to be responsible. It just gives attorneys, I suppose, another factor that we can give to the jury to consider in deciding whether the driver was negligent. Finally, Gloria asks, if you see someone using a device like this while they're driving, can you call 911 and report them? And Gloria, I suppose you could, and I haven't talked to the police about this, but I'm guessing they'd rather that you don't. Look, wow, another technical difficulty. I apologize for that, but look, the 911 is for emergencies, life-threatening emergencies, and I'm sure they would rather you not clog up their system with calls because you see somebody using their cell phone. Certainly if somebody's creating hazard, if somebody's creating an emergency situation on the road, go ahead and call 911, but don't call just if you see somebody using their cell phone. Just keep your distance, stay safe, and get home. And that is FAQ Friday for today. When do you call a lawyer, and what's the benefit of calling a lawyer? How do lawyers get paid? And what is the impact of the new DUI-E law on civil claims? Thank you so much for all your questions. We'll be back next Friday with our third installment of FAQ Fridays. And I appreciate you engaging in this dialogue with me. If you do have any questions that you'd like me to address in my next video, please reach out and I'll make sure to get to them. Again, from me and all of us at the law offices of Matthew Dubin, be safe, watch out for yourself and others. Enjoy the rest of your summer, and I'll see you next Friday. Bye.